everyone, ಎಲ್ಲರಿಗೂ ಸ್ವಾಗತ. ಆಲ್ ಇಂಡಿಯಾ ಬಾರ್ ಎಕ್ಸಾಮಿನೇಷನ್ 20 ದಟ್ ಇಸ್ AIBE 20 ಗೆ ಪ್ರಿಪೇರ್ ಆಗ್ತಿರುವಂತ ಪ್ರತಿಯೊಬ್ಬ ಸ್ಟೂಡೆಂಟ್ ಈ ವಿಡಿಯೋ ನಿಮಗೋಸ್ಕರ. ದಟ್ ಇಸ್ ಪ್ರೀವಿಯಸ್ ಇಯರ್ ಕ್ವೆಶ್ಚನ್ ಪೇಪರ್ ಅನ್ನ ಸಾಲ್ವ್ ಮಾಡುವಂತ ಈ ವಿಡಿಯೋ ಲೆಕ್ಚರ್ ಸೀರೀಸ್ ಅಲ್ಲಿ this AIBE 19 ಪೇಪರ್ ರೀಸೆಂಟ್ ಲಾಸ್ಟ್ ಪೇಪರ್ ದಟ್ ಇಸ್ 2025 ಇದೇ ವರ್ಷ ನಡೆದಿರೋದು ಅಂಡ್ ರೀಸೆಂಟ್ ಲಾಸ್ಟ್ ಪೇಪರ್ ಅಂತಂದ್ರೆ 19 ಈಗ ನೀವು ಬರೆಯೋದು AIBE 20 ಪೇಪರ್ ಆಗಿರುತ್ತೆ. ಸೊ ಇದಕ್ಕೆ ಮುಂಚೆನೂ ನಾವು ಈಗಾಗಲೇ 18, 17, 16, 15 ಎಲ್ಲ ಸಾಲ್ವ್ ಮಾಡಾಗಿದೆ. ಸೊ ನೀವು ವಿಡಿಯೋನ ಲಿಂಕ್ಸ್ ನಿಮಗೆ ಪ್ಲೇಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸಿಗುತ್ತೆ, ಚೆಕ್ ಮಾಡಬಹುದು. ಅಂಡ್ ಪ್ರೀವಿಯಸ್ ವಿಡಿಯೋಸ್ ಯಾವುದೇ ಕಾಂಪಿಟೇಟಿವ್ ಎಕ್ಸಾಮ್ ಆಗಿರಲಿ ಬೇಸ್ ಫೌಂಡೇಶನ್ ಕ್ರಿಯೇಟ್ ಮಾಡುತ್ತೆ. ಸೊ ಹಾಗಾಗಿ ಪ್ರೀವಿಯಸ್ ಇಯರ್ ಕ್ವೆಶನ್ ಪೇಪರ್ಸ್ ನಿಮಗೆ ಅಟ್ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಎಕ್ಸಾಮ್ನ ನೀವು ಯಾವ ಒಂದು ರೀತಿಯಲ್ಲಿ ಕಂಡಕ್ಟ್ ಆಗುತ್ತೆ, ಹೇಗೆ ನೀವು ಪ್ರಿಪ್ರೇಷನ್ ಮಾಡ್ಕೋಬೇಕು ಅನ್ನೋದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ. ಸೊ ದಿಸ್ ಪೇಪರ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಅಂಡ್ ಪೇಪರ್ ಇಂದ ಸುಮಾರು ಕ್ವೆಶನ್ಸ್ ರಿಪೀಟ್ ಕೊಡೋದು ಸಹ ಆಗತ್ತೆ. ಸೊ ಹಾಗಾಗಿ ಪ್ರತಿಯೊಂದು ಪೇಪರ್ನು ಸರಿಯಾಗಿ ನೋಡಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಇದು AIBE 19 ಪೇಪರ್ನ ಸೆಟ್ ಎ ವಿಡಿಯೋ ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ. ಸೊ ನಾನು ಸ್ವಾತಿ ಲಾ ಅಕಾಡೆಮಿಗೆ ಸ್ವಾಗತ. ಅಂಡ್ ಈ ಪೇಪರ್ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಸೆಟ್ ಆಗಿರುವಂತದ್ದು ಸೆಟ್ ಎ ಪೇಪರ್. ಸೊ ಆಸ್ ಯು ಕ್ಯಾನ್ ಸಿ 3 hours ನ ಪೇಪರ್, ಓಪನ್ ಬುಕ್ ಎಕ್ಸಾಮಿನೇಷನ್, 100 marks, 100 ಕ್ವೆಶನ್ಸ್ ಇರುತ್ತೆ, ಯಾವುದೇ ನೆಗೆಟಿವ್ ಮಾರ್ಕಿಂಗ್ ಇರೋದಿಲ್ಲ. ಅಂಡ್ ಬೇರಾಕ್ಸ್ ಅವೈಲೇಬಲ್ ಇದೆ, ನೀವು ತಗೊಂಡು ಹೋಗ್ಬೋದು ಬೇರಾಕ್ಸ್. ಅಂಡ್ ಪ್ಲೀಸ್ ನಿಮ್ಮದೇ ಆದಂತ ಒಂದು ಸೆಟ್ ಪರ್ಚೇಸ್ ಮಾಡಿ ನಿಮ್ಮ ಬೇರಾಕ್ಸ್ ನೀವು ಕ್ಯಾರಿ ಮಾಡಿ, ರಾದರ್ ದ್ಯಾನ್ ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಅವ್ರ ಹತ್ರ ಬೇರಾಕ್ಸ್ ಕೇಳಿ ಕಾಪಿ ಮಾಡ್ತಿದ್ರಿ ಅಂತ ಅನಿಸ್ಕೊಳ್ಳೋದಕ್ಕಿಂತ ನಿಮ್ಮ ಬೇರಾಕ್ಸ್ ಕಾಪಿ ತಗೊಂಡು ಹೋಗಿ. ಕ್ಲಿಯರ್? ಸೊ ಟು ಸ್ಟಾರ್ಟ್ ಆಫ್, ಕ್ವೆಶನ್ ನಂಬರ್ 1. In which case was a registered society held to be an authority for the purpose of Article 12? Article 12 ನ ಪರ್ಪಸ್ಗೆ ರಿಜಿಸ್ಟರ್ಡ್ ಸೊಸೈಟಿ ಅಂತ ನಾವು ಯಾವ ಕೇಸ್ ಅಲ್ಲಿ ಹೆಲ್ಡ್ ಮಾಡಿರೋಂಥದ್ದು? ದಟ್ ಈಸ್ ಅಜಯ್ ಹಾಸಿಯಾ ವರ್ಸಸ್ ಖಾಲಿದ್ ಮುಜೀಬ್, ಲ್ಯಾಂಡ್ ಮಾರ್ಕ್ ಜಡ್ಜ್ಮೆಂಟ್. ಅಂಡ್ ಸಿನ್ಸ್ ಎಲ್ಲಾ ಕ್ವೆಶನ್ಸ್ ನಿಮಗೆ ಬೇರಾಕ್ಟ್ ಇಂದನೇ ಬರೋದಿಲ್ಲ, ಯು ಹ್ಯಾವ್ ಟು ನೋ ದ ಕಾನ್ಸೆಪ್ಟ್ ಆಸ್ ವೆಲ್. ಅಂಡ್ ಆ ಕಾನ್ಸೆಪ್ಟ್ ನ ಸರೌಂಡಿಂಗ್ ಕೇಸ್ ಲಾಸ್ ಎಕ್ಸೆಟ್ರಾ ಇರೋದು ನಿಮಗೆ ಗೊತ್ತಿರಬೇಕಾಗಿರುತ್ತೆ. In which case did Supreme Court of India held that fundamental rights cannot be waived? Fundamental rights na waive off ಮಾಡೋದಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೆಲ್ಡ್ ಮಾಡಿದ್ದು ಬಶೀರ್ನಾಥ್ ವರ್ಸಸ್ IT ಕಮಿಷನರ್ ಕೇಸ್. By which constitutional amendment was clause 4B inserted into Article 16? ಯಾವ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಇಂದ ಕ್ಲಾಸ್ 4B ಆಡ್ ಮಾಡಿದ್ದು ಆರ್ಟಿಕಲ್ 16 ಗೆ? ಸೊ ಇಟ್ ಈಸ್ A, ಆರ್ಟಿಕಲ್ 81st ಅಮೆಂಡ್ಮೆಂಟ್ ಇಂದ. ನೆಕ್ಸ್ಟ್, question number 4. Which of the following statement is correct about 106th Constitutional Amendment Act? So ಇದನ್ನ ಆಕ್ಚುಲಿ ಕ್ವೆಶನ್ ಅನ್ನ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಲಾಗಿತ್ತು ಬಿಕಾಸ್ ಆಫ್ ದ ರಾಂಗ್ ಆನ್ಸರ್ ಕೀಸ್ ಸೆಟ್. ಸೊ ಹಾಗಾಗಿ ಈ ಕ್ವೆಶನ್ ವಿಡ್ರಾ ಆಗಿದೆ ಅಂಡ್ ಇದರಲ್ಲಿ ಆನ್ಸರ್ ಮಾಡಿರೋಂಥವರಿಗೆ ಗ್ರೇಸ್ ಮಾರ್ಕ್ಸ್ ಸಿಕ್ಕಿರುತ್ತೆ. ಸೊ ನಿಮಗೆ ಕ್ವೆಶನ್ ಅರ್ಥ ಆಗಲ್ಲ, ನೀವು ಕ್ವೆಶನ್ ಅಟೆಂಪ್ಟೆಡ್ ಆಗಿ ಬಿಟ್ಟು ಬಂದ್ರೆ ನಿಮಗೇನು ಗ್ರೇಸ್ ಮಾರ್ಕ್ಸ್ ಸಿಗೋದಿಲ್ಲ. ಅಟೆಂಪ್ಟ್ ಮಾಡಿ ತಪ್ಪು ಆಗಿದ್ದು ಎಕ್ಸಾಮಿನರ್ ಕಡೆಯಿಂದ ದೆನ್ ನಿಮಗೆ ಗ್ರೇಸ್ ಮಾರ್ಕ್ ಅನ್ನೋದನ್ನು ಸಹ ಸಿಗತ್ತೆ. ಓಕೆ, ಸೊ ನೆಕ್ಸ್ಟ್ ಕ್ವೆಶನ್ ನಂಬರ್ 5 ಆಲ್ಸೋ ದಿಸ್ ವಾಸ್ ಆಲ್ಸೋ ವಿಡ್ರಾನ್. ದ ಪಾರ್ಲಿಮೆಂಟ್ ಎನಾಕ್ಟ್ಸ್ ದ ಫೇರ್ ಹೌಸಿಂಗ್ ಆಕ್ಟ್ 2024 ನ ರಿಲೇಟೆಡ್ ಇದನ್ನು ಸಹ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಲಾಗಿತ್ತು. ಓಕೆ, ಸೊ ಫೇರ್ ಹೌಸಿಂಗ್ ಆಕ್ಟ್ ರಿಲೇಟೆಡ್, ಸೊ ಔಟ್ ಆಫ್ ಸಿಲೆಬಸ್ ಎಕ್ಸೆಟ್ರಾ ಅಂತ ಹೇಳಿ, ಬಟ್ ಇದು ಔಟ್ ಆಫ್ ಸಿಲೆಬಸ್ ಅಲ್ಲ, ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕ್ವೆಶನ್ ಆಗಿತ್ತು. 6. The reports of the Controller and Auditor General of India relating to the accounts of the state shall be submitted to CAG CAG ರಿಪೋರ್ಟ್ ಏನಿದೆ ಅದನ್ನ ಯಾರಿಗೆ ಸಬ್ಮಿಟ್ ಮಾಡಲಾಗುತ್ತೆ? ದಟ್ ಇಸ್ ಟು ದ ಗವರ್ನರ್, ಅದು ಸಬ್ಮಿಟ್ ಆಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್, ವಿಚ್ ಆಫ್ ದ ಫಾಲೋಯಿಂಗ್ ಆರ್ಟಿಕಲ್ ಆಫ್ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಇಂಡಿಯಾ ಡಿಕ್ಲೇರ್ಸ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಶಾಲ್ ಬಿ ಅ ಕೋರ್ಟ್ ಆಫ್ ರೆಕಾರ್ಡ್? ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನ ಕೋರ್ಟ್ ಆಫ್ ರೆಕಾರ್ಡ್ ಅಂತ ಹೇಳ್ತಿರೋದು ಆರ್ಟಿಕಲ್ 129. ವಿಚ್ ಆರ್ಟಿಕಲ್ ಡೀಲ್ಸ್ ವಿತ್ ದ ಪವರ್, ಪ್ರಿವಿಲೇಜಸ್ ಅಂಡ್ ಇಮ್ಯುನಿಟೀಸ್ ಆಫ್ ಪಾರ್ಲಿಮೆಂಟ್ ಅಂಡ್ ಇಟ್ಸ್ ಮೆಂಬರ್ಸ್? ಸೊ ಪಾರ್ಲಿಮೆಂಟ್ ಹಾಗೂ ಅವರ ಮೆಂಬರ್ಸ್ ನ ಇಮ್ಯುನಿಟೀಸ್ ಅನ್ನ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಿರೋದು ಆರ್ಟಿಕಲ್ 105. ವಿಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಕ್ಟ್ ಇನ್ಸರ್ಟೆಡ್ ಪ್ರೊವಿಷನ್ಸ್ ರಿಲೇಟೆಡ್ ಟು GST ರಿಲೇಟೆಡ್ ಪ್ರೊವಿಷನ್ಸ್ ಯಾವ ಅಮೆಂಡ್ಮೆಂಟ್ ಇಂದ ಬಂದಿದ್ದು? 101, ದಟ್ ಇಸ್ 101st ಅಮೆಂಡ್ಮೆಂಟ್ ಆಕ್ಟ್ ಇಂದ. ಹೂ ಕ್ಯಾನ್ ಇನಿಷಿಯೇಟ್ impeachment proceedings against the President of India? President of India na against impeachment proceedings it can be initiated in either house of the parliament. Next, ಹೊಸ ಲಾ ಹಾಗೂ ಹಳೆ ಕ್ರಿಮಿನಲ್ ಲಾ ಎರಡು ಬರುತ್ತೆ. ಸೊ ಮೇಕ್ ಶ್ಯೂರ್ ಇದೇ ನಿಮ್ಮ ಫಸ್ಟ್ ಪೇಪರ್, ಇಲ್ಲಿಂದ ನಿಮ್ಮ ಹೊಸದು ಹಾಗೂ ಹಳೆ ಲಾಸ್ ಎರಡನ್ನೂ ಕೇಳಕ್ ಶುರು ಮಾಡಿದ್ದು. ಸೊ ಇದೇ ಸೇಮ್ ನಿಮಗೆ ಈಗಲೂ ರಿಪೀಟ್ ಆಗುತ್ತೆ. ಸೊ BNS, that is ಭಾರತೀಯ ನ್ಯಾಯ ಸಂಹಿತ, considers force to be criminal force. ಯಾವಾಗ ಫೋರ್ಸ್ ಅನ್ನ ಕ್ರಿಮಿನಲ್ ಫೋರ್ಸ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ? when it is used intentionally without consent, causing injury, fear or annoyance ಅಂತ ಹೇಳುವಾಗ. According to BNS, what is the maximum fine for making or as document that resembles a currency note or the bank note under the section 182 clause 1? So same resemblance, that is duplicate currency note ಅನ್ನ ಅಥವಾ ನಮಗೆ ಏನು ಕರೆನ್ಸಿ ನೋಟ್ ಅನ್ನ ಮಾಡೋದು ಯಾವ ಒಂದು ಆಕ್ಟ್ ಅಲ್ಲಿ, ದಟ್ ಇಸ್ 300 rupees, 100, 500 rupees and 1000 rupees ಇದೆ. ಸೊ ಇದು ಸೆಕ್ಷನ್ 182 clause 1 ಪ್ರಕಾರ ದಿಸ್ ರಿಸೆಂಬಲ್ಸ್ 300 rupees. ನೆಕ್ಸ್ಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಪ್ರೊವಿಷನ್ಸ್, 300 rupees ನ ಫೈನ್ ಇಂಪೋಸ್ ಆಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಪ್ರೊವಿಷನ್ಸ್ ಆಫ್ ಭಾರತೀಯ ನ್ಯಾಯ ಸಂಹಿತ, ದ ರೈಟ್ ಆಫ್ ದ ಪ್ರೈವೇಟ್ ಡಿಫೆನ್ಸ್, ರೈಟ್ ಆಫ್ ಪ್ರೈವೇಟ್ ಡಿಫೆನ್ಸ್ ಏನಿದೆ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಎಕ್ಸ್ಟೆಂಡ್ಸ್ ಟು ದ ವಾಲಂಟರಿಲಿ ಕಾಸಿಂಗ್ ಆಫ್ ಡೆತ್ ಆರ್ ಆಫ್ ಎನಿ ಅದರ್ ಹಾರ್ಮ್ ಟು ದ ರಾಂಗ್ ಡೂವರ್ in which of the following offences committed the attempting to be committed. ಯಾವ offense ಅಲ್ಲಿ right to private defense RPD can exceed up to causing death. in ನಾವು ಮಾತನಾಡ್ತಿರೋದು ಪ್ರಾಪರ್ಟಿನ ಕನ್ಸರ್ನ್ ಅಲ್ಲಿ ರೈಟ್ ಟು ಪ್ರೈವೇಟ್ ಡಿಫೆನ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಬಾಡಿ ಹಾಗೂ ಪ್ರಾಪರ್ಟಿ ಎರಡೂ ಇದೆ. ಇಲ್ಲಿ ಪ್ರಾಪರ್ಟಿನ ಕನ್ಸರ್ನ್ ಅಲ್ಲಿ ಯಾವಾಗ ಇಟ್ ಎಕ್ಸ್ಟೆಂಡ್ಸ್ ಟು ರೈಟ್ ಟು ಕಾಸಿಂಗ್ ಡೆತ್ ಆಲ್ಸೋ ಅಂತ ಹೇಳುವಾಗ ಇಟ್ ಈಸ್ ರಾಬರಿಗೂ ಇದೆ, ಹೌಸ್ ಬ್ರೇಕಿಂಗ್ ಆಫ್ಟರ್ ಸನ್ಸೆಟ್ಗೂ ಇದೆ. ಥೆಫ್ಟ್, ಮಿಸ್ಚೀಫ್ ಆರ್ ಹೌಸ್ ಟ್ರೆಸ್ಪಾಸ್ ಇಲ್ಲ. ಸೊ ಇಟ್ ಇಸ್ ಸಿ 1 and 2 both. Next, Rajesh in a heated argument with Sunil strikes him with a heavy iron rod. The blow fractures Sunil's arm and he is unable to use it for several weeks. So use ಮಾಡೋದಕ್ಕೆ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ. ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಕನ್ಫರ್ಮ್ಸ್ ದಟ್ ಫ್ರಾಕ್ಚರ್ ಅಮೌಂಟ್ಸ್ ಟು ಗ್ರೀವಿಯಸ್ ಹರ್ಟ್. ಸೊ ಗ್ರೀವಿಯಸ್ ಹರ್ಟ್ ಆಗಿದೆ ಅನ್ನೋದು ಗೊತ್ತಾಗಿದೆ. Now which of the following offense commit ಆಗಿದೆ? ಸಿಂಪಲ್ ಹರ್ಟ್ ಅಲ್ಲ, ವಾಲಂಟರಿಲಿ ಕಾಸಿಂಗ್ ಗ್ರೀವಿಯಸ್ ಹರ್ಟ್, ವಾಲಂಟರಿಲಿ ಕಾಸಿಂಗ್ ಹರ್ಟ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 324 IPC, attempting to commit culpable homicide under section ಅಲ್ಲ. ಸೊ 325 but voluntarily causing grievous hurt ಏನಿದೆ this was correct. ಆದ್ರೂ ಸಹ ಈ ಕ್ವೆಶನ್ ವಾಸ್ withdrawn. ಸೊ ಹಾಗಾಗಿ ಏನು ರಾಂಗ್ ಆನ್ಸರ್ಸ್ ಕೊಟ್ಟಂತ ಒಂದಿದ್ರಲ್ಲಿ ವಿತ್ಡ್ರಾ ಆಗಿತ್ತು. ಸೊ ಗ್ರೇಸ್ ಮಾರ್ಕ್ಸ್. 15. Amit, intending to cause the death of Vijay, attacks him with wife. Vijay sustains severe injuries and dies on spot. The investigation reveals that Amit acted with knowledge and his actions were likely to cause death. ಬೇಕಂತಲೇ ಡೆತ್ ಕಾಸ್ ಮಾಡೋದಿಕ್ಕೆ ಅಂತಾನೆ ಹೊಡೆದಿರೋದು. However, there is no evidence of the premeditation or intent to murder Vijay. ಆದರೆ ಯಾವುದೇ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ, ಹಾಗೆ ಇಂಟೆಂಟ್ ಇರಲಿಲ್ಲ ಕೊಲೆ ಮಾಡೋದಿಕ್ಕೆ. Which of the following offences has Amit committed? ಅಮಿತ್ ಯಾವ offense ಅನ್ನ ಕಮಿಟ್ ಮಾಡ್ದ? ಮರ್ಡರ್ ಅಲ್ಲ, culpable homicide not amounting to murder 304 of IPC. Amit and Rani decide to break into the house at night with the intent of stealing valuables. They use a crowbar to force open the door, but before they can take anything, the owner of the house, Vikram, unexpectedly arrives home. Amit and Rani panic and run away without stealing anything. The police arrest them by following morning based on the complaint from Vikram. Which of the following offences have they committed? So ಇವರು ಏನು ಮಾಡಿಲ್ಲ ಅಂತಲ್ಲ, they have attempted to commit theft. So answer is 16B. And also house trespass with intent to commit theft ಅನ್ನೋದು ಕರೆಕ್ಟ್ ಆನ್ಸರ್ ಆಗುತ್ತೆ. ಬಿಕಾಸ್ ಅವರು ಮನೆಗೆ ನುಗ್ಗಿದ್ರು ಅನ್ನೋದು ನಮಗೆ ಹೇಳಿರೋದ್ರಿಂದ ಟು ದ ಪಾಯಿಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಹೌಸ್ ಟ್ರೆಸ್ಪಾಸ್ ಅನ್ನೋದಾಗುತ್ತೆ. Punishment for rape in case where the victim is a woman below the age of 16 or 12 is included in the section of which section of BNS? So ಯಾವ section include ಆಗುತ್ತೆ? It is section 65. And which in a new offense of snatching has been introduced in BNS. ಸ್ನ್ಯಾಚಿಂಗ್, ಚೈನ್ ಸ್ನ್ಯಾಚಿಂಗ್, ಮೊಬೈಲ್ ಸ್ನ್ಯಾಚಿಂಗ್ ಮುಂಚೆಯಿಂದ ಇತ್ತು, ಬಟ್ ಸೆಕ್ಷನ್ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅದಕ್ಕೆ ಪನಿಷ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿರೋದು. ವಿತ್ ಸೆಕ್ಷನ್ BNS defines snatching as an offense. So snatching is defined in 304. Consider the following statements and answer the question given below. Mr. Patel, being a police officer, receives a complaint and information that Raju was involved in a robbery of the bank and has also helped to hide the valuable properties in his farm, as stated by two villagers. With this regard, consider the following. The police officer, Mr. Patel, may arrest Raju without warrant. ಯಾವಾಗ without warrant arrest ಮಾಡಬಹುದು ಅನ್ನೋದು ಪ್ರಶ್ನೆ. So, Raju can be arrested only if he commits a non-cognizable offense in the presence of Mr. Patel? No. Since the reasonable complaint against Raju has been received and there is a strong suspicion exists due to testimony of villagers, he can be immediately arrested. So immediately arrest ಮಾಡೋದಕ್ಕೆ villagers ನ testimony help ಆಗುತ್ತಾ, ಅಥವಾ Raju can be arrested only when he tries to escape or run away. Correct, ಇದರಲ್ಲಿನೂ ಸಹ ನಮಗೆ ನಡೆಯುತ್ತೆ. So next 2 is also done. Raju can be arrested as to prevent him from making an inducement, threat or promise to any person acquainted with the facts and circumstances. ನಮಗೆ ಇಲ್ಲಿ correct answer would be 2 and 4. I mean yes, 2 and 4 correct answer ಆಗುತ್ತೆ. So answer is option B. Raju can be arrested only when he tries to escape or run away ಅಂತ ಅಲ್ಲ, but 2 and 4 would be the correct answer. That is suspicion ಇದೆ and threat, inducement, promise ಮಾಡುವಂತ ಒಂದು ಪರಿಸ್ಥಿತಿ ಇದೆ. BNSS introduced the provision of registration of FIR relating to commission of cognizable offence irrespective of area where the offence is committed. This FIR is known as zero FIR ಅಂತ ಕರಿತೀವಿ. ಹಾಗೆ ಈ FIR ಕೂಡ ಸಹ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಆಗಿದೆ. Next 173 section. The BNSS mandates a forensic team to visit the crime scene to collect the evidence for the offence punishable under imprisonment for at least years of 7 ಗಿಂತ ಜಾಸ್ತಿ ವರ್ಷದ ಒಂದು ಪನಿಷ್ಮೆಂಟ್ ಇರುವಂತ ಆಫೆನ್ಸ್ ಆಗಿದ್ದಾಗ ನಾವು ಫಾರೆನ್ಸಿಕ್ ಟೀಮ್ will lead to the investigation. Which section of BNSS allows the trial in absentia of proclaimed offender? In the absence of proclaimed offender, section 356 will lead for trial. With ಅಂದ್ರೆ proclaimed offender ಅವನು ಅಬ್ಸ್ಕಾಂಡ್ ಆಗಿದ್ದಾನೆ, ತಪ್ಪಿಸ್ಕೊಂಡು ಓಡಾಡ್ತಿದ್ದಾನೆ, ಸೊ ಹಾಗಾಗಿ ವಿತೌಟ್ ಹಿಮ್ ಟ್ರಯಲ್ ಅನ್ನ ನಡೆಸಿ. Which section of BNSS facilitate trials and proceedings to be held in electronic mode ಅಲ್ಲಿ ಟ್ರಯಲ್ ನಡೀಬಹುದು ಅಂತ ಹೇಳ್ತಿರೋದು 530. Which section of BNSS repeals the CRPC? ಸೊ ಯಾವ ಸೆಕ್ಷನ್ BNSS ರಿಪೀಲ್ ಮಾಡ್ತಿದೆ CRPC ದು? It is 531. So which section mandates, that is 531 ಅಲ್ಲಿ ನಾವು ಹೇಳ್ತಿರೋದು, ಇನ್ನು ಮುಂದೆ CRPC ಇರೋದಿಲ್ಲ, BNSS ಇರುತ್ತೆ ಅನ್ನೋದನ್ನ ಹೇಳ್ತಿರುವಂತ ಪ್ರಾವಿಷನ್ ಆಗಿರುತ್ತೆ. Next 25. Which section mandates the state government repeat and notify a witness protection scheme for the state with a view to ensure the protection of witness? So witness protection scheme ಅಂತ ಹೇಳೋದು ಈ ಕ್ವೆಶನ್ ಆಕ್ಚುಲಿ ವಿಡ್ರಾ ಆಗಿದೆ, ಬಟ್ ಇಟ್ ವಾಸ್ ಈಗ ನಮ್ಮ ಒಂದು ಪ್ರಾವಿಷನ್ಸ್ ಏನು ಚೇಂಜ್ ಆಗಿದೆ, ಇಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಪ್ರಾಪರ್ಲಿ ಗಿವೆನ್, ಸೊ ಹಾಗಾಗಿ ದಟ್ ಇಸ್ ಸೆಕ್ಷನ್ ಆಪ್ಷನ್ಸ್ ಇಲ್ಲ, ಹಾಗಾಗಿ ಆನ್ಸರ್ ವಿಡ್ರಾನ್. ನೆಕ್ಸ್ಟ್, which section of BNSS mandates the appointment of a designated police officer in each district and police station to provide information about arrested individuals to the general public? Answer is option C, section 37. Which section of BNSS introduces provisions for identifying, attaching and forfeiting of the property of proclaimed offender located outside India? It is section 86. 28. Which of the section of BNSS places restriction on the adjournment of trial ensuring the expeditious resolution of cases? So it is 346. So direct questions ene idiyallanu. A suit is pending in the district court district court A, but one of the parties, Meera, requests its transfer to district court B, claiming that judge in the court A is biased. The opposing party, Ravi, objects, stating that the request is baseless. Who has authority to decide whether the suit can be transferred? ಯಾರು ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ about the transfer of suit? So it is decided by the High Court or the Supreme Court. Maya files a suit in the court A for recovery of the sum of money from her neighbor Neha. During the proceeding, Neha requests that a third part, Seema, be added to the suit. Third party. As Seema is allegedly liable for the debt, Maya objects, claiming that Seema is not necessary party. Court A then reviews the application and decides that Seema should be included as a defendant to this case. So, which principle of the CPC is applied in this situation? ಯಾವ ಪ್ರಿನ್ಸಿಪಲ್ ಅನ್ನ ಅಪ್ಲೈ ಮಾಡ್ತಿದ್ದೀವಿ? It is Order 1, Rule 10, joinder and substitution of parties. 31. Which section of CPC allows for the appeal from the original decree? Appeal from original decree, section 96. So appeal from second decree is section 100. Second appeal. Under the CPC, what is the maximum time limit for filing the written statement in a suit? ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ ಇಟ್ ಇಸ್ 90 days. Next, which section of the CPC provides exemption of the President of India and the governors of the state from personal appearance in court? So exemption is given in section 133, which is what is the term used for the court's power to transfer a case from one court to another court in the CPC. One court in the another court ge transfer of suit anta karitivi. Further, question number 35, under which order of the CPC the procedure for the summary suits is provided? Summary suits ge procedure is provided in order 37. Which section of CPC deals with the principle of res judicata? Section 11. Dash of CPC provides for an interpleader suit. It is section 88. Which section of CPC provides for payment of compensatory cost? Compensatory cost 35A. Which word is inserted in section 22 of the BSA that was not present in section 24 of Evidence Act? Section 22 ಅಲ್ಲಿ ಇವಾಗ ಏನಿದೆ, section 24 of Evidence Act ಅಲ್ಲಿ ಇಲ್ಲದ್ದು ಅಂತ ಹೇಳಿದ್ರೆ these are the provisions regarding confession ಬಗ್ಗೆ ಮಾತನಾಡ್ತಿರುವಂಥದ್ದು. ಸೊ ಇಟ್ ಇಸ್ coercion. ಮುಂಚೆ ಥ್ರೆಟ್, ಇಂಡ್ಯೂಸ್ಮೆಂಟ್, ಪ್ರಾಮಿಸ್ ಅಷ್ಟೇ ಇದ್ದು ಈಗ coercion ಅನ್ನ ಆಡ್ ಮಾಡಿದೀವಿ. Existence of course of business when relevant is discussed in dash. ಕೋರ್ಸ್ ಆಫ್ ಬಿಸ್ನೆಸ್ ಅನ್ನೋದೇನಿದೆ ಅದು ರಿಲೆವೆಂಟ್ ಆಗತ್ತೆ ಅಂತ ಹೇಳಿರುವಂತ ಪ್ರೊವಿಷನ್ ಇಸ್ section 14 of BSA. In a criminal trial, Rajesh is the accused of theft. During the investigation, the police recover a stolen laptop from the location known to be frequented by Rakesh. His fingerprints were found on the laptop according to Bharatiya Sakshi Adhiniyam 2023. How should the court interpret the piece of evidence? ಇದನ್ನ ಹೇಗೆ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಬೇಕು ಫಿಂಗರ್ಪ್ರಿಂಟ್ ರಿಲೇಟೆಡ್ ಅಂತ ಹೇಳುವಾಗ ಆನ್ಸರ್, the recovered laptop and fingerprints are circumstantial evidence that can be considered along with other evidence but do not by themselves prove the guilt beyond reasonable doubt. Beyond reasonable doubt ಪ್ರೂವ್ ಮಾಡೋದಕ್ಕೆ ನಮಗೆ ಇನ್ನಷ್ಟು ಎವಿಡೆನ್ಸಸ್ ಕೊರಾಬರೇಟ್ ಮಾಡಬೇಕಿರುತ್ತೆ. 42 of A, where a document is executed in several parts like printing, lithography or photography, video recording, computer resource as the electronic or digital record, the BSA classifies each part as. ಇದನ್ನ ಹೇಗೆ ಕ್ಲಾಸಿಫೈ ಮಾಡ್ತೀವಿ? ಸೊ ಆನ್ಸರ್ ಇಸ್ ಎ, ಪ್ರೈಮರಿ ಎವಿಡೆನ್ಸ್. ದೀಸ್ ಆಲ್ ಆರ್ ವೆರಿ ವೆಲ್. ಇದನ್ನ ಪ್ರತಿಯೊಂದನ್ನು ಸಹ AIB 20 ಚಾಂಪಿಯನ್ಸ್ ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಪ್ರತಿಯೊಂದೂ ಸಹ ಡೀಲ್ ಆಗಿದೆ. ದಟ್ ಇಸ್ ಸ್ವಾತಿ ಲೋ ಅಕಾಡೆಮಿ ಕಡೆಯಿಂದ ನಡೀತಿರುವಂತ ಈ ಬ್ಯಾಚ್ ನಿಮಗೆ ಎವ್ರಿ ಮೇಜರ್ ಆಕ್ಟ್ ನ ಪ್ರತಿ ಸೆಕ್ಷನ್ಸ್ ಅನ್ನ ಪ್ರಾಪರ್ ಆಗಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ನಡೆದಿರುವಂತ ಕ್ಲಾಸಸ್. ಸೊ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ನೀವು ಈ ಬ್ಯಾಚ್ಗೆ ಜಾಯ್ನ್ ಆಗ್ಬೋದು ಫಾರ್ ಯೋರ್ ಪ್ರಿಪರೇಷನ್ ಫಾರ್ AIB. ಈ ವರ್ಷ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಇಯರ್ ನಿಮಗೆ ಈ ಒಂದು ಕ್ಲಾಸಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗುತ್ತೆ. Which section of BSA provides that no court shall require any communication between the ministers and the President of India to be produced before it? So, it is option B, section 165. According to section 46 of Bharatiya Sakshi Adhiniyam, the character evidence is relevant in civil cases. Character evidence ಯಾವಾಗ relevant ಆಗುತ್ತೆ? Only when related to the other relevant fact ಗೆ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ಬರುವಾಗ. 45. As per section 78 clause 2 of BSA 2023, presumption about the officer signing or certifying a document is. So signing or certifying document is the officer held the official character claiming when signing or certifying the document. Section 146 of BSA, when the leading questions are permissible in the court proceeding. Cross-examinationally leading questions are permissible. So this is being held in leading question are permitted during cross-examination. Option D, when the matters are introductory, undisputed and sufficiently proved. Which of the following is a characteristic of mediation? So characteristic of mediation antandre, it involves a neutral third party who facilitates negotiation between the parties. A dispute arises between ABC Limited versus XYZ Private Limited regarding a contract that both parties had entered into. The agreement includes an arbitration clause which states that any dispute shall be referred to the arbitrator. However, the parties failed to agree on the appointment of the arbitrator. Which of the following provision of the Arbitration and Conciliation Act 1996 would be applicable to resolve the issue of the appointment of an arbitrator? ಹೇಗೆ ರಿಸಾಲ್ವ್ ಮಾಡ್ಕೊಳ್ಳೋದು? ದ ಕೋರ್ಟ್ ವಿಲ್ ಅಪಾಯಿಂಟ್ ಅನ್ ಆರ್ಬಿಟ್ರೇಟರ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 11 ಆಫ್ ದ 11 if the parties fail to agree on one. So next, which of the following is not an advantage of using ADR? ADR alternative dispute resolution ನ ಯೂಸ್ ಮಾಡೋದಕ್ಕೆ ಯಾವುದು ಅಡ್ವಾಂಟೇಜ್ ಅಲ್ಲ ಅಂತ ಹೇಳೋದು? ಇಟ್ ಇಸ್ ಆಲ್ವೇಸ್ ರಿಸಲ್ಟಿಂಗ್ ಇನ್ ದ ಬೈಂಡಿಂಗ್ ಡಿಸಿಷನ್ ಆಗಿರುತ್ತೆ. ನೆಕ್ಸ್ಟ್ 50, Kiran and Meera are involved in an arbitration where the Kiran was awarded rupees 10 lakh as compensation. Meera refuses to pay the amount, arguing that the award was not enforceable because of certain procedural irregularities in the arbitration process. Kiran decides to approach the court to enforce the arbitral award. Which of the following provision of Arbitration and Conciliation Act governs the enforcement of the arbitral award? ಯಾವ ಸೆಕ್ಷನ್ ಇದನ್ನ govern ಮಾಡ್ತಿದೆ? It is section 36 of the act allows the automatic enforcement of an arbitral award unless it's set aside by the court. 51, which section of discusses with regard to Sapinda relationships under the Hindu Marriage Act 1955? It is section question option D, that is section 3 clause F, subclause 1 and 2 and explanation to 3G5 clause 5. Under the section 15 of Hindu Marriage Act, the divorced person may marry again. Divorced person may marry again. Have to wait for a period of 1 year from the date of decree. Idella illa, and even this question was withdrawn. So next, have to wait for a period of 6 months. No, may marry immediately thereafter without the leave of the court as a matter of right. None of these. So answer actually idralli yadu sari alla. Marry immediately but after the decree of the court. And next 53, Aarti and Rajesh have been married for 5 years. Over time, Aarti has been subjected to continuous cruelty by the Rajesh, which has led to the emotional and mental distress. Aarti decided to file for divorce on the grounds of cruelty, section 13(1)(1)(a) of the Hindu Marriage Act 1955. Which of the following statement is true regarding the grounds of the divorce under the Hindu Marriage Act? Grounds of divorce alli namage Aarti can seek the divorce on the grounds of cruelty as long as she proves that the mental physical cruelty agide. On what matters where Dayabaga is silent, what prevails? Dayabaga law silent idre yen prevail agutte? Mitakshara prevail agutte. Nisha and Akash are separated and they both seek custody of their minor child, Arav. Nisha has been the primary caregiver while Akash claims that he can provide better financial stability for Arav. They both approach the court under the Guardian and Wards Act 1890. Which of the following factor will the court primarily consider in the determining the custody of Arav? So namige ee ondu factor na decide ಮಾಡೋದಕ್ಕೆ it is the welfare and the best interest of the child ಯಾರ ಕಡೆ ಇದೆ ಅವರ ಒಂದು ಇದರಲ್ಲಿ ಆಗುತ್ತೆ. That is 55. 56, match the following. So spoken words ಏನಾಗುತ್ತೆ etc. match the following related question. Answer is your spoken words ಅಂತ ಹೇಳುವಾಗ Sunnat ul Takrir, Deepika versus Cat. So this is your A is your option 3. B, that is Deepika versus CAT anta heluvaga a typical relationship ಬಗ್ಗೆ atypical relationship. Silence is Sunat ul Haq. So ನಿಮಗೆ ಒಂದೆರಡು ಗೊತ್ತಿದ್ರೂ ಸಹ ಆಕ್ಚುಲಿ ಉಳಿದದನ್ನ ಮಾಡಬಹುದು. ಫಾರ್ ಮೀ ಸೈಲೆನ್ಸ್ ಸುನತ್ ಉಲ್ ಹಕ್ ಗೊತ್ತಿರುವಂಥದ್ದು. Ascar versus Kartar Singha, and this is customary law related. And Shaira Banu versus Union of India, everyone knows about this and it is maintenance related. So clause E ಗೆ 6 ಅಂತ ಹೇಳೋದು ಎಲ್ಲ ಆಪ್ಷನ್ಸ್ ಅಲ್ಲೂ ಇದೆ, ಬಟ್ ಉಳಿದಿದ್ದು ಸೈಲೆನ್ಸ್ ಅಂಡ್ ಎಕ್ಸೆಟ್ರಾ ಒಂದೆರಡು ಎಕ್ಸೆಟ್ರಾ ಗೊತ್ತಿದ್ರೆ you can mark the answer. So answer here is option C. Fatima, a Muslim woman, has been divorced by her husband Imran through talaq. Fatima is now seeking maintenance from Imran for herself and her two minor children. Imran argues that Fatima has remarried and therefore is not entitled for any evidence. So any maintenance under Muslim law, which of the following statement is true regarding Fatima's claim for maintenance? ಯಾವುದು ಸರಿ ಅಂತ ಹೇಳ್ತಿರೋದು. So here this question is withdrawn. ಸುಮಾರು ಕ್ವೆಶನ್ಸ್ AIBE 19 ಅಲ್ಲಿ ವಿಡ್ರಾ ಆಗಿದೆ ಡ್ಯೂ ಟು ನಾಟ್ ಪ್ರಾಪರ್ಲಿ ಫ್ರೇಮ್ಡ್ ಆಪ್ಷನ್ಸ್ ಅಂತ ಆಗಿರಬಹುದು. The remedy of restitution of conjugal rights as given in the section Act 1955 Hindu Marriage Act ಪ್ರಕಾರ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ? ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಕಾಂಜುಗಲ್ ರೈಟ್ ಸೆಕ್ಷನ್ 9 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. In which case a prison inmate sent a letter to the Supreme Court describing physical torture which became a pioneer in the public interest litigation, though the court later abandoned the practice of considering letters. So but ಯಾವ ಕೇಸಲ್ಲಿ? ಸುನಿಲ್ ಬಾತ್ರಾ ವರ್ಸಸ್ ಡೆಲ್ಲಿ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಕೇಸಲ್ಲಿ. In the early 1980s, a social activist group discovered severe exploitation of laborers working in stone quarries near Delhi. The worker, including many children, were working in extremely hazardous conditions, living in makeshift shelters, and were effectively trapped in a cycle of the debt and forced labor. The conditions revealed systematic violations of fundamental human rights. The Supreme Court was approached to look into the dire circumstances of the working person there, and one of the following views of the court was sustained in the said case. Identify the following. ಸೊ ಯಾವ ಕೇಸಲ್ಲಿ ಈ ಒಂದು ಕೇಸ್ನ ಬಗ್ಗೆ ಮಾತನಾಡ್ತಿರೋದು ಇಲ್ಲಿ ಅಂತ ಹೇಳಿದ್ರೆ, ಇಟ್ ಇಸ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರೆಕಗ್ನೈಸ್ ರೈಟ್ ಅಗೇನ್ಸ್ಟ್ ಫೋರ್ಸ್ಡ್ ಲೇಬರ್ ಆಸ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ derived from the article right to life and human dignity under article 21. So 1980s na ee ondu case. So read the given statement and choose the correct option. So it is in PIL cases the court plays a passive role similar to the traditional cases, and PIL is primarily focused on individuals disputes. So answer, both statements are false. Idu individual disputes ಬಗ್ಗೆ ಖಂಡಿತ ಅಲ್ಲ, and passive role ಕೂಡ ಅಲ್ಲ. It plays very active role in PIL. Given below are two statements, one labeled assertion and the other is reason. ಈ ರೀತಿ applicability based and assertion, reason etc. These many question ಈ ತರ ಕೇಳಿದಂತ ಫಸ್ಟ್ ಪೇಪರ್ AIB 19. ಬಟ್ ಸೇಮ್ ಈಗ ನಾವು ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಬಹುದು 20 ಪೇಪರ್ಗೆ. ಸೊ ಹಾಗಾಗಿ ಯು ಹ್ಯಾವ್ ಟು ಬಿ ಪ್ರಿಪೇರ್ಡ್ ಫಾರ್ ದಿಸ್. ಅಸರ್ಷನ್. ಸೊ ಇದರ ದ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡೈ ಈಸ್ ರಿಲ್ಯಾಕ್ಸ್ಡ್ ಇನ್ PIL ಕೇಸ್. ಸೊ ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡೈನ ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡಿದೀವಿ, ದಟ್ ಕೋರ್ಟ್ನ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಇದೆಯಾ ಇಲ್ಲ ಅನ್ನೋದನ್ನ ಇಟ್ಸ್ ರಿಲ್ಯಾಕ್ಸ್ಡ್. PIL allows any public spirited person to approach the court on behalf of those who cannot represent themselves. True. So ನಮಗೆ ಆನ್ಸರ್ ವುಡ್ ಬಿ both A and R are true, and R is the correct explanation of A. Which of the following best defines delegated legislation? So delegated legislation anta heladre, these are laws made by administrative authority under the powers given by them by parliament. So that is called as delegated legislation. In 2020 at Dorodo village, the panchayat elections could not happen due to COVID pandemic. While the tenure of panchayat was getting over the year, that year itself, Mr. Haribansh represented the people that year and the panchayat post dissolution of the panchayat tenure and made a law exercising the delegated power wide the panchayati raj of the state to restrict their economic activities per day to 100 only. In which case the following case is allowed or restricted? It was in MCD versus Birla Cotton Mills case. Which of the following is or are not the grounds for judicial review or administrative action? ige grounds yaudu alla. So yaudalla, it is only public opinion is not a ground. Illegality, irrationality, proportionality becomes the ground. Answer would be your D. What does conflict of interest refer to in professional ethics? ಸೊ ಪ್ರೊಫೆಷನಲ್ ಎಥಿಕ್ಸ್ ಅಂತ ಮಾತನಾಡುವಾಗ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತಂದ್ರೆ ಏನು? ಇಟ್ ಇಸ್ ಸಿಚುವೇಶನ್ ವೇರ್ ಪರ್ಸನಲ್ ಇಂಟ್ರೆಸ್ಟ್ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ವಿತ್ ಪ್ರೊಫೆಷನಲ್ ಡ್ಯೂಟೀಸ್. ಅಡ್ವೊಕೇಟ್ Mr. X was representing a client Mr. Y in a property dispute case. During the proceeding, advocate Mr. X accepted a bribe from the opposing party to delay the case, causing significant harm to Mr. Y's interest. Moreover, Mr. X failed to inform his client about the critical hearing dates, leading to adverse judgments. So, on the basis of the above problem, select the correct option. It is a violation of the rules made by Bar Council of India for the professional ethics. Next, the nature of proceeding in the case of the professional misconduct. Criminal in nature, quasi-criminal in nature, neither civil nor criminal, or civil in nature. Answer is C. Only quasi-criminal in nature. Appropriate procedural safeguards help reduce the threats of objectivity and counter any perception of possible bias. Which of the following is or are not procedural safeguards? Yadu procedural safeguards alla. again this question was being withdrawn. Next, question number 70. As per 2 clause 84, share means share in the share capital of a company and includes dash. So it includes debentures, preference shares, stocks, bonds. It includes only stocks. So answer is your option C, that is only 3. Section 43 of the Companies Act provides for kinds of share capitals. A manufacturing company in the city of Surat named X has been discharging untreated industrial waste into a nearby river and violating the provisions of Environment Protection Act 1986 and the Water Prevention and the Control of Pollution Act 1974. This has resulted in the severe pollution, making the river water unsafe for drinking and harming aquatic life. Local farmers and the residents who rely on the river for irrigation and the daily needs have started facing health issues and crop failures due to the contaminated water. Despite multiple complaints, the local pollution control board, no action has been taken against the company. Based on the above problems, select the correct answer. General agi environmental laws anta heluvaga namige environmental laws ge very pioneer case anta barodu MC Mehta cases ಆಗಿರುತ್ತೆ. So here untreated water etc. MC Mehta cases indane namige lead agodu. And illi it is violation of section 24 of the Water Prevention and Control of Pollution Act 1974. Next, which of the following act is popularly known as umbrella legislation? So yavadana umbrella legislation antivi, the Environment Protection Act 1986 is called as umbrella legislation because it includes all these three. Which of the following is or are included under the section 2(1) clause W of the Information Technology Act 2000 describing the intermediary? So idanalli answer namige option B, that is cyber cafes, social media platforms and internet service providers. So iವರು ನಮಗೆ intermediaries ಅಂತ ನಾವು ಡಿಫೈನ್ ಮಾಡಿದೀವಿ 2(1) clause W ಅಲ್ಲಿ. Malati, a small business owner, runs an online clothing store. Recently, she noticed that her website had been hacked and her customers' personal information, including the names, address and payment details, was stolen. Shortly after some of her customers reported unauthorized transaction on her account, Malati wishes to file a complaint against the incident. On the basis of the above problem, select the correct option. So answer namige, it is punishable under section 66 of IT Act, definitely yes, and also it is punishable under 66 and customers can also claim the compensation under certain circumstances. So namige correct answer would be option C athava option A as given in your answer key, final key al bandirodu. Which of the following is or are included under the definition of the employer given under the Industrial Relations 2020? So it is option D 1, 2 and 3, occupier of factory, contractor and manager of the factory. Iವರು ನಮಗೆ ಈ ಡೆಫಿನೇಷನ್ ಅಲ್ಲಿ ಫಾಲೋ ಆಗ್ತಾರೆ. ವಿಚ್ ಆಫ್ ದ ಫಾಲೋಯಿಂಗ್ ಲೆಜಿಸ್ಲೇಷನ್ ಹ್ಯಾಸ್ ಬಿನ್ ಇನ್ಕ್ಲೂಡೆಡ್ ಅಂಡರ್ ದ ಸೋಷಿಯಲ್ ಸೆಕ್ಯೂರಿಟಿ ಕೋಡ್ 2020? ಸೊ ಸೋಷಿಯಲ್ ಸೆಕ್ಯೂರಿಟಿ ಕೋಡ್ ಅಲ್ಲಿ ಇನ್ಕ್ಲೂಡ್ ಆಗಿರೋದು ಮೆಟರ್ನಿಟಿ ಬೆನಿಫಿಟ್ ಆಕ್ಟ್, ಪೇಮೆಂಟ್ ಆಫ್ ಗ್ರಾಚ್ಯುಟಿ ಆಕ್ಟ್ and also payment bonus act alla, employment exchanges, compulsory notification and vacancies act. It is answer 1, 2 and 4. So option C. Dash have not been set up under the provisions of Industrial Dispute Act 1947 for adjudication of industrial disputes in an organization. So it is your option B, environmental tribunals. XYZ Textiles Limited, a manufacturing company, recently terminated 4 workers without providing any compensation. The termination was because of the misconduct on the part of the workers. The company issued a show cause notice and the disciplinary inquiry conducted against them. On the basis of the recommendations of the committee, the services which was rejected by the management, aggrieved by the rejection of the workers, have filed a case of those employees were terminated. The workers claimed that the retrenchment compensation complaint in the labor code under the provision of the Industrial Dispute Act. Based on the above problem, select the correct answer. So correct answer is your option A, the termination does not amount to the retrenchment, hence no compensation. 80. Miss J, a banker, refuses to honor the check of Miss F. Though she was having sufficient balance, yet it doesn't suffer any loss to Miss F. Miss F can file the case under which scenario? ಯಾವ scenario ಅಲ್ಲಿ case file ಮಾಡಬಹುದು? It is injuria sine demnum. Mr. B told Mr. A to leave the premises in occupation of Mr. A. When Mr. A refused, then Mr. B collected some of his workmen who mustered around Mr. A. They tucking up their sleeves and aprons and threatened to break the plaintiff's neck. He did not leave. Under which tortious act Mr. A can file the case? So yearly case file ಮಾಡಬಹುದು. It is under assault. Miss J, knowing while taking the lift that driver Mr. T was under the influence of alcohol constantly, car met with an accident and Miss J got injuries and she had filed the case for compensation. Which defense could be claimed by Mr. T? Mr. T can claim voluntary non-fit injuria. So voluntarily ಬಂದಾಗ ಇಂಜುರಿಗೆ you have consented and ಅದನ್ನ ನಾವಿಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡೋದಿಲ್ಲ. Voluntarily if you have joined. So Mr. K is the owner of the building containing large number of rooms and have derived a considerable income by letting them. Mr. Y is the owner of an adjacent cotton mill which erected after the occupation by Mr. K. Owing to noise and smoke of the mill, several rooms remain vacated that results into loss for Mr. K. Examine relevant tort of the case. So it is C, nuisance anna create ಮಾಡ್ತಿರುವಂಥದ್ದು. 84, there was a collision between two buses, one owned by the government and other was a private bus, wherein the private bus was coming from the wrong side and the government bus was coming rashly, neither slowing down his bus after seeing the other bus. Determine the tortious act. So it is under your contributory negligence. The term income is described in the Income Tax Act 1961 under section 2 clause 24. Mr. X deposits 65,000 in the term deposit of 5 years with the post office to avail the tax deduction under section 80 clause C. 80C, assuming Mr. X does not opt for the concessional tax regime under section 115 B AC of the Income Tax Act 1961. On the basis of above problems, select the correct option. It is Mr. B is not guilty of either tax evasion or tax avoidance. Next, 87. Read the given statement and choose the correct option. Statement 1. Agricultural income is exempt from the tax under section 10 clause 1 of Income Tax Act 1961. Statement 2. Tax on non-agricultural in case of income. In the case of non-agricultural income exceeds basic exemption limit and the agricultural income exceeds 5,000 is determined by the scheme of partial integration of non-agricultural income with the agricultural income. So, ಇಲ್ಲಿ ಯಾವ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕರೆಕ್ಟ್ ಅಂಡ್ ಯಾವುದು ಸ್ಟೇಟ್ಮೆಂಟ್ ತಪ್ಪು, ಎರಡೂ ಸ್ಟೇಟ್ಮೆಂಟ್ ಸರಿಯಾಗಿದೆ. ಸೊ ಹಾಗಾಗಿ both the statements are correct. Rent free accommodation provided by an employer to the employee is a prerequisite under section 17 clause 2 of Income Tax Act. An agreement not enforceable by law is stated to be void under 2 clause G. The concept of invalid guarantee is covered under section A. Invalid guarantee is covered under 142 to 144. A real estate developer entered into the contract with the B, the owner of the piece of the prime land for purchase of her property. The contract stipulated that A would pay 50 lakhs in advance and remaining 1 crore within 6 months. In return, B agreed to transfer the title of the land. However, after receiving the advance payment, B refused to execute the sale deed, claiming that she received a better offer from another buyer. A demanded the enforcement of the contract under the Specific Relief Act 1963. But B denied his claim. A has to file the suit in court of law. On the basis of above problem, select the correct answer. So, illi correct answer namige A may file a suit in the civil court having the power under CPC. Next, A transfers a piece of land to B on the condition that B shall not transfer the land to anyone else for next 10 years. In case B has no right to transfer the land to someone else for the next 10 years. On the basis of above problem, select the correct option. So, correct option would be it amounts to the conditional limitation transfer of property. Next, Mr. Rajesh issued a check of 50,000 to his supplier, Mr. Sharma, for the payment of the goods purchased. When Mr. Sharma deposited the check, it was written by the bank with the remark of insufficient funds. On the basis of above problem, select the correct option. So it is B, a complaint in writing to be made by Mr. Sharma to the court within 1 month, that is 30 days from the date of dishonor of check. Section 31 of SRA is related to. Section 31 relates to cancellation of instruments. How the recovery of specific immovable property may be enforced. Specific immovable property recover hege enforce agodu. So a person is entitled to the possession of specific immovable property may recover it in the manner provided by the CPC. Which section of law of contract defines a proposal may be revoked at any time before but not after communication of its acceptance is complete as against the proposer. It is defined in section 5. According to the Land Acquisition Act, Land Acquisition, Rehabilitation and Resettlement 2013, governments can acquire land for, so it can acquire land for strategic purpose, projects for families affected by projects, and but for the public-private partnership projects where the government ownership of the land will remain with the government. Answer is option D, 1, 2 and 3. Land Acquisition Act 2013 in India has replaced which earlier legislation? So it has replaced Land Acquisition Act 1894. Soham, an independent software developer, created a mobile app called FitLife that provides personalized fitness plans. He registered the app's name and logo under the trademark law and copyrighted the app's source code. However, 6 months after its launch, Soham discovered a competing app called the FitLife, which a similar logo and feature being marketed by the large tech company. Soham believes that competing app copied elements of his source code and intentionally used confusingly similar name and logo to mislead the customers. So in this case, what can be done on the basis of this? Correct option ಏನು ಅಂತಂದ್ರೆ, under trademark law, can Soham claim infringement for the use of similar name and logo by the competing app? Definitely yes, he can prove that the name are confusingly similar. Bari spelling ಒಂದು change ಅಷ್ಟೇ, but it was completely similar. What is the duration of copyright protection for the literary works in India? So literary works, it is lifetime of the author plus 60 years, until the lifetime of author plus 60 years na ಒಂದು ಕಾಪಿರೈಟ್ ಪ್ರೊಟೆಕ್ಷನ್ ಅನ್ನೋದು ಇರುತ್ತೆ. ರೀಸೆಂಟ್ ಆಗಿ ವಿ ಹ್ಯಾವ್ ಆಲ್ಸೋ ನೋನ್ ದಟ್ ರವೀಂದ್ರನಾಥ್ ಟ್ಯಾಗೋರ್ ಅವರ ಒಂದು ಲಿಟ್ರರಿ ವರ್ಕ್ಸ್ಗೆ ಇದ್ದಂಥ ಕಾಪಿರೈಟ್ ರಿಲೀಸ್ ಆಗಿದೆ ಅಂಡ್ ಇಟ್ ಇಸ್ ನೌ ಇನ್ ದ ಪಬ್ಲಿಕ್. ಸೊ ಇಟ್ ಇಸ್ 60 years plus ಲೈಫ್ ಟೈಮ್ ಪ್ಲಸ್ 60 years ಆಗಿರುತ್ತೆ. ಸೊ ಬೈ ದಿಸ್ ವಿ ಕಂಪ್ಲೀಟ್ ಆರ್ 100 questions ಆಫ್ AIB 19 ನ ಪೇಪರ್. ಸೊ ಇಲ್ಲಿ ತನಕ ನಿಮಗೆ ಅರ್ಥ ಆಗಿದೆ ಅನ್ನೋದಾದ್ರೆ, ಸ್ವಾತಿ ಲಾ ಅಕಾಡೆಮಿ ಕಡೆಯಿಂದ AIB 20 ಚಾಂಪಿಯನ್ಸ್ ಬ್ಯಾಚ್ ಅನ್ನೋದು ನಡೀತಿದೆ. ಸೇಮ್ ಇಂಗ್ಲಿಷ್ ಆ್ಯಂಡ್ ಕನ್ನಡ ಲ್ಯಾಂಗ್ವೇಜ್ ಅಲ್ಲಿ ಆ್ಯಂಡ್ ನಿಮಗೆ ಕಂಪ್ಲೀಟ್ ಫುಲ್ ಕೋರ್ಸ್ ಬೇರಾಕ್ಸ್ ಅನ್ನ ಕವರ್ ಆಗ್ತಿರೋಂಥದ್ದು ವಿತ್ ಕಾನ್ಸೆಪ್ಚುಯಲ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆ್ಯಂಡ್ ಈ ಎಲ್ಲಾನು ಸಹ ನಿಮಗೆ ಎಟ್ ಅ ವೆರಿ ನಾಮಿನಲ್ ಪ್ರೈಸ್ ಅನ್ನೋದು ನಡೀತಿದೆ. ಸೊ ಹಾಗಾಗಿ ಯು ಕ್ಯಾನ್, ಇಫ್ ಯು ಆರ್ ಇಂಟ್ರೆಸ್ಟೆಡ್, ಕಾಲ್ ಟು 9650849915 and enroll yourself to these batches. ಅಥವಾ ಸ್ವಾತಿ ಲಾ ಅಕಾಡೆಮಿ ವೆಬ್ಸೈಟ್ಗೆ ಪ್ಲೇಸ್ಟೋರಲ್ಲಿರುವಂಥ ಅಪ್ಲಿಕೇಶನನ್ನು ಡೌನ್ಲೋಡ್ ಮಾಡಿಕೊಂಡು ನೀವು ಎನ್ರೋಲ್ ಮಾಡ್ಕೋಬಹುದು. ಇಲ್ಲ ವೆಬ್ಸೈಟ್ swathilaw.com ವಿಸಿಟ್ ಮಾಡಿ ಕೂಡ ಸಹ ನೀವು ಎನ್ರೋಲ್ ಮಾಡ್ಕೋಬಹುದು. ಸೊ ದಟ್ ಈಸ್ ಇಟ್ ಫಾರ್ ದಿಸ್ ವಿಡಿಯೋ. ಇಷ್ಟ ಆಗಿದೆ ಆ್ಯಂಡ್ ನಿಮಗೆ ಕ್ಲಾಸಸ್ ಇದೇ ರೀತಿ ಕಂಟಿನ್ಯೂ ಲಾ ರಿಲೇಟೆಡ್ ಬೇಕು ಅಂತ ಹೇಳುವಾಗ ಯು ಕ್ಯಾನ್ ಸಬ್ಸ್ಕ್ರೈಬ್ ಟು ದ ಚಾನೆಲ್ ಸ್ವಾತಿ ಲಾ ಅಕಾಡೆಮಿ. ಹಾಗೆ ಫಾರ್ ಫರ್ದರ್ ವಿಡಿಯೋಸ್ ಆ್ಯಂಡ್ ನಿಮಗೆ ಈ ವಿಡಿಯೋ ಇಷ್ಟ ಆಗಿದೆ ದೆನ್ ಪ್ಲೀಸ್ ಡೂ ಶೇರ್ ವಿತ್ ಅಟ್ ಲೀಸ್ಟ್ ಒನ್ ಆಫ್ ಯುವರ್ ಫ್ರೆಂಡ್ಸ್, ಸೊ ದಟ್ ಒಬ್ಬ ಫ್ರೆಂಡಿಗೆ ಈ ಒಂದು ಇನ್ಫಾರ್ಮೇಶನ್ ಅಥವಾ ಈ ಪೇಪರ್ನ ನಾಲೆಜನ್ನು ಅವರಿಗೂ ಸಹ ಸಿಗಲಿ. ಆ್ಯಂಡ್ ಅವೇರ್ನೆಸ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಬೆಳೆದಷ್ಟೂ ಸಹ ಒಳ್ಳೆಯದು ಟು ಬಿ ಇನ್ ಅ ಅವೇರ್ ಸೊಸೈಟಿ. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಆ್ಯಂಡ್ ಥ್ಯಾಂಕ್ ಯು ಫಾರ್ ಆಲ್ರೆಡಿ ಸಬ್ಸ್ಕ್ರೈಬಿಂಗ್ ಮೈ ಚಾನಲ್. ಥ್ಯಾಂಕ್ ಯು.